this panel. I will have the pleasure to chair the session. I am Sergio Carrera, a Senior Research Fellow at CEPS and also a professor at EUI. And I'm very glad to be here, to participate in this very interesting conference. And just briefly, the topic of this panel, which is, by the way, organized by the FRA, the EU Fundamental Rights Agency, deals with the fundamental rights implications of EU large-scale information systems and the use of biometrics. A highly topical matter in Brussels, politically, a key priority in the Security Union agenda of Commissioner King Task Force, Security Union, the notion of interoperability and this idea of linking everything under the sun, and by this I mean all existing information systems, EU information systems. As a background, CEPS has recently published a book covering and going in detail on this issue. It's called Constitutionalizing the Security Union. It's freely downloadable in our website. And it actually provided background to the comprehensive assessment of Julian King. We brought together academics, some of them have participated in this event, to nurture their thinking and to raise issues of fundamental rights and rule of law when reflecting about this notion of interoperability. Now, interoperability until recently has been an empty shell, meaning there was a lot of talk about it, but there was nowhere to be seen what it meant. Until recently that the Commission presented a specific proposal on this. In the CEPS book, we raise a number of questions concerning purpose limitation, who has access to which information and why, for which use, for which purpose, and what are the societal impacts and fundamental rights implications of blurring law enforcement with issues of asylum, migration, and people whose status makes them highly vulnerable. Now, briefly about the order of the day. As I said, I will be chairing this meeting, and I made myself already very popular with the speakers, sending them very specific guidelines regarding time for their speeches. We have short time to go deep into this fascinating topic. I will briefly lay down the format for you to get a picture. So we will start with Diana Dimitrova from FIS. She will moderate the session and she will scope also the panel, and then we will move into the presentations. So Diana, would you like to?
Thank you very much for the introduction, Sergio, and thank you all for coming here immediately after lunch. I know it's a difficult session, I mean in terms of timing. I want to welcome also the panelists who will have the extremely important task of tackling several very difficult questions, legal questions, concerning the right of access, the right to information, as well as the discussing the interoperability concept which Sergio just mentioned. However, to better understand the questions, to better understand the interoperability concepts and the following discussions on the legal questions, I will start with a very short warm-up where I will present briefly the existing large-scale information systems, and then I will pass on the word to our speakers. So probably you see the scheme here on the big screens, and you will see the abbreviations of several databases, which I will briefly present to you. As you can see explained on the screen, all of them concern or contain data of third country nationals, meaning non-EU citizens, and one of them, the Schengen Information System, contains also data of European citizens, and I will explain briefly why and what data. And you can also see here some keywords on the screen referring to the purposes of the different databases, and you can already guess that each of these databases has its own purpose. And let me start by giving an example with the Schengen Information System, or SIS, indicated there. which contains biometric data, which is the topic of our panel, namely facial images and fingerprints. And according to the recent proposal of the European Commission to revise the Schengen Information System, in the future, this system might contain also DNA and palm prints. The purpose of this database, or what it contains, is different alerts, on one hand concerning entry-exit bans for third country nationals, entry bans against third country nationals, or the other category of, broad category of alerts is against persons who are wanted by the criminal, by the police, for example, victims of crime or suspects or convicted people, or also lost and stolen documents, vehicles and banknotes. Then you can see also the VIS. This stands for the Visa Information System, whose purpose is to administer the visa policy of the European Union by collecting biographical and biometric data, fingerprints and facial images of all those third country nationals who apply for a short stay visa. And then we have Eurodac, which is a database containing currently only the fingerprints and the sex of asylum seekers and refugees who arrive in the European Union. The purpose being to determine which member state is responsible for examining their asylum application or administering the Dublin Regulation, as it is otherwise called. And in the future, the Eurodac might contain also facial images and alphanumeric data. Now, all the three databases I just mentioned are already in operation. They have existed for a long time by now. And the EU is planning to create 3 new databases. One of them, which will be probably the first to come, is the entry-exit system, which already has a legal basis and is about to be developed. And it will record the entries and exits of all those who are third country nationals and visit the EU for a short stay. And it will also collect the facial images and fingerprints of the these tourists, let's call them this way. You see ECRIS, TCN ECRIS on the screen, which stands for European Criminal Records. A judicial tool cooperation, which will also contain fingerprints and facial images. And ETIAS, just to briefly mention it, will not contain fingerprints or facial images. It will be only biographical data of all those third country nationals visiting the EU for a short stay, but who do not need a visa. Now, probably by now you got a bit confused because it was a lot of information, and you might be asking yourselves, can all these concerned people understand all these purposes? How, and stemming from this question, how easy is it for them to exercise their rights to access to their data, to information, to the correction of this data, especially when it comes to biometrics, which is a very special category of data. So luckily, we have on our panel distinguished panelists who can elucidate more this topic, and I will pass on the floor to Anne-Charlotte Nygård from the Fundamental Rights Agency, because the Fundamental Rights Agency conducted a study studying the fundamental rights implications of the biometric data on those large-scale biometric databases, and I hope that we will hear some interesting results from this study. So the floor is yours, Lotta.
Thank you. Does it work? Yeah. Thank you. Thank you very much, Diana. I would also like to thank you as the moderator of this panel, also for having helped so much in the organization of it, and also Sergio for sharing it, as well as the other panelists first. Diana already explained the systems, so we can go right into the topic directly. As Diana said, we are we exactly posed this question to ourselves a few years ago. Do people involved in the whose data is collected in IT systems in the areas migration, asylum, visa, do they understand what's happening with their data, how it's used, and what they should do if something goes wrong based on false data in the system? We conducted 2 phases of research for this, and when I say we, I just do not mean that we, a few people in the migration sector in the FRA, did it ourselves. We subcontracted the research. We had firstly our own FRANet partners, which are long-term partners doing research for the FRA in all member states, mapping out the procedures, finding out what are the relevant practices and procedures, because these are fields beyond the public websites, so to say. Then we had a second phase of contracted field research, where we were then helped by ETIAS Research and Consulting, together with the Spanish Research Council, who set up an extensive network that they had in 6 member states. This was Belgium, Spain, Italy, Germany, Poland, and Sweden, to look at experiences in a more individual basis and more concrete way. They conducted qualitative interviews as well as small-scale surveys. Now, the results of our research, which was published in a report, hopefully to be published at the last few days of March this year, if things go according to plan. This research and results do not tell anything about the quantitative magnitude of a certain problem or opportunity or something we have noticed. It is mapping out what is happening in real life, basically in Europe today in this area, shedding light of otherwise hidden phenomena and bringing to the forefront the experiences people have had to increase their understanding. Okay, it's very interesting because it doesn't appear on this screen at least. Let's try again. It's right. Okay, good. We looked at the right to information. The right to information is an aspect of the right to good administration, which is included in the Charter of Fundamental Rights. The right to information is included in Eurodac, in VIS, and also in the forthcoming entry-exit system and ETIAS. But it can be restricted in SIS II and in ECRIS, which will hold criminal records of third country nationals, ECRIS-TCN. What we found basically, and this is in our report we have extensively written about this, I would in a few keywords says it's a matter of stressful situation, both for the person concerned, but many times for the staff also, which means that mistakes can happen, but also that the right to information is usually or often not provided in the way it should be. We leave behind a sense of non-transparency. And here is we have a quote of somebody who our researchers then spoke to, who said, so how long will they be kept, the fingerprints? When people have then go home and have time to think over what has happened. Okay, I gave my fingerprints, what does this mean? Who can see them? My employer, would the employer see them? And questions like this, which is just indication of that the right to information does not always work as it should. In the case of the visa information system, where the individual is in a complete different situation, asking for a visa, there's usually a complete personal setup, complete different, of course, than being in in a situation where you seek protection. But still few remember that they have been informed at all, although that information of the processing is included in the application form itself, and usually the oral information provided focuses only on the process, the practical things when you take the fingerprints, which is usually done by the service providers. So, as I said, we conducted a small-scale surveys, and then trying to ask the visa applicants what they remembered, and they said they only 11% said that they had received any information about how the data will be processed, and 2% that they would have received any information about the possibilities that they would have to exercise the right to right of access to their data, correction or deletion of data, and most didn't remember to have received information at all. Now, a trend that we have in the development of IT systems, which has been going on for a few years, and it's also very strong in the present policy, the legal developments that's going on, is to have added purposes added to the instruments on the basis of which authorities can access and use data. In our research, we did record some incidents of unlawful access that have happened, information shared further, sometimes out of ignorance, even ending up with third countries, although it was information about asylum seekers. So that's a real risk, coupled with the information that we have, that it's also something that contributes to reluctance to fingerprinting, that asylum seekers are afraid that that information may end up in third countries. Concerning law enforcement access, there were a little bit of limited controls. In case to see if safeguards were really respected. Access by immigration law enforcement. This is one of the added purposes which is coming on to all the systems apart from ECRIS-TCN. Possibilities to flee persecution by, let's say, many times unintended impacts of the IT systems is in a possible future interoperability solution with Interpol's database of stolen, lost travel documents, which might prevent the person to leave the country and seek protection. The same thing is entry bans, which limit persons to leave the country, but also something which states can work around if there is a wish by issuing a visa of limited territorial validity, for instance. Then there is also sometimes positive aspects contributing to protection is if a person can prove the correct identity, for instance, by pointing to this, because the person has been in Europe before. This can also help a person to prove the identity. Connected to law enforcement access is the possibility that databases could have to detect trafficking victims, which was, as we saw, if one may say, a little bit underused, this possibility at the embassies and their service provider. Then we come to the accuracy of the data, which is an issue and impacts a lot. And I think the next panelist will go further into this, what this could make in a concrete case. In short, impacting on the Dublin rules, it's not only Eurodac, also VIS can do it, but we have a lower quality threshold for VIS. And that's one point. The second point is that any difficulties with fingerprinting impact on the trustworthiness and credibility. It is believed that the person avoid fingerprinting. Third point, any problem with the document easily lead to a suspicion of fraud. There is a difficulty to rebut the false assumption. There is a high trust in the databases and what the databases tell you. The databases and the biometrics of biometrics, apart from a technical complexity of understanding how it works, but for lawyers who support asylum seekers and migrants, in addition to perhaps a generally low awareness about their importance in various procedure, lead to a situation where the lawyers we interviewed found that there's sometimes very difficult situation to rebut a false assumption. What we also saw are fairly low numbers of persons who could really exercise the right of access, correction, and deletion of data stored. Also, there are mistakes in the system. It's difficult to understand the procedures. There are administrative hurdles, language barriers, and few specialized lawyers in this field. Concerning the rights of the child, it's also something that we devote a fairly extensive chapter to in our report. And we look at the quality issues, how a long retention period impact on the quality of the matching down later along the lines. And this is against the background of the trend to lower the age as of which biometrics can be taken. In Europe, the Eurodac proposal speaks about 6 years, for instance. Children, unaccompanied and accompanied, not being informed, are not understanding what's happening when their personal data is taken and fingerprints are taken. And we also see if there is a way to optimize the databases for tracing missing and adopted children by combining the data that is available in the system, looking at new proposals SIS II in combination with the new proposals for Eurodac, and further even an interoperability solution in that respect. But I think, did I make it all right with the timeline? Okay, good, thank you.
Thank you very much for your for presenting the results. They were very interesting, and I wanted to quickly ask you something. Basically, the presentation concerned the current state of the laws, the current usage of the systems. We are aware of the recent proposal of the Commission on Interoperability. So I was wondering, what would be your perspective concerning the fundamental rights risks, but also opportunities that a possible interoperability could offer?
Yes, thank you. Yes, I mean to start with this. This project has been accompanied by very speedy and fast developments at the EU level. Interoperability being one among them, and FRA participated in the high-level expert group of the Commission on Interoperability. The proposals were then put on the table on the 12th of December, going in some aspects further than the discussions in that expert group. Basically, what the interoperability would do is to replace some data, store links between identities, and store biometric templates, and all this to improve the possibility to make the right identification of a person to be able to fulfill the purposes foreseen in the existing instruments. Meaning, in short, the purposes wouldn't go beyond what's now, but this mechanism to do the correct, to put in place a mechanism to do a correct identification of a person involves a number of things which merit a further very careful consideration of the fundamental rights implications and risks, but also possibilities to gain something for the fundamental rights benefits in terms of better identification. There are some issues related to purpose limitation that is to be defined later in stage, which may raise issues in regards to legal clarity and foreseeability. The right to information, as I already said, in the present system, when we looked at 3 systems, this was difficult to fulfill for the states. And I wonder how that could play out in a situation of interoperability, how the right to information, how can that be accessed and conveyed, and how can member states comply with their obligation to provide information in an interoperable situation. This is another, I think, tricky question. The same holds to the right to access, correction, and delete data, to understand where to turn in a situation of interoperability, where the mistakes in the beginning could be in one of the databases made interoperable. When it comes to the effects on the right to asylum, it's basically those things which I already mentioned. Already, some safeguards are included in this. For instance, there is a prohibition for sharing data with third countries. On the other hand, there's also a certain safeguard in relation to lost and stolen travel documents, but not a reminder for the states that there's still legitimate reasons, could be even if you depart with a stolen travel or not the genuine travel documents, because you didn't have any other choice basically to leave your country. So there is this other thing, which is the impossibility to enroll fingerprints and biometric mistakes, as the system very much relies on biometrics. All those implications and risks we saw in the research we did are definitely valid in an interoperability context as well. The same goes for those that we saw in relation to rights of the child. So.
Thank you very much. I will catch on something you said, which is we don't know exactly how interoperability will play out in the future, but I think it will be very useful to hear examples whether already with the existing systems, which are not interoperable yet, whether there have been any difficulties. And luckily we have here Viktoria Nyström, sorry if I mispronounce your name, who is a lawyer from Sweden and who is working with real cases, and probably we can hear some examples about these rights of the data subject in practice, and also see the link between the data protection rights and the right to family life, to private life, to asylum, and so on and so forth. So I pass on the word then to Viktoria.
Thank you so much. I'm just going to see that I get my PowerPoint. Yes. The first case I'm going to talk about is a fingerprint match that turned out not to be a match. So we had a man seeking asylum in Sweden. He was told he left his fingerprints in another EU state, although he claimed that he had never been in that state. He was eventually transferred to that other EU state with police escort. Upon arrival, it was concluded that it was not his fingerprints, and in the end he was sent back to Sweden. And then one might think that, well, what's the problem? He was sent back to Sweden, he got his asylum case tried in Sweden, so no problem. But this case uncovered a lot of problems with registration of data, and of course written government statements as well. The way it was handled had a big impact on the asylum seeker on many levels. Sorry. Oh, I forgot to. We'll have that one. First of all, his asylum case was delayed around 6 months to a year. And he had an increase of mental health issues. And that affected him not only during this period of time, but also later on. So that's important to remember, that it's not only in the moment that this happens, that they have the mental health issues. It continues. So, and he was in fact incarcerated part of the time before being transferred to that other country. And that had a negative effect on him, as well as it was an invasion of his privacy integrity. Once he was transferred, he had no legal, he had no right to legal assistance. Or actually, he didn't have any right to legal assistance in the moment that he was considered a Dublin case. That is to say that he was going to be transferred to that other country, to another EU country. And he had no money to pay for his own lawyer, so someone had to do it without getting paid if they were going to help him. When the mistake was discovered in that other EU country, he didn't have access to legal representation, or at not least immediately. And his former legal representation, that is to say us, we didn't get any information about him being returned to Sweden. I would say that with some luck, we managed to find out that he had been returned. And of course, he would have gotten a legal representation in Sweden when he got back, but not the same legal representation that knew about the problems from before. And I think that's important to have the same legal representation. And one thing that was really, really interesting was that he was mistrusted from the moment they found the fingerprints. That mistrust followed him, not only in the first procedure, but also during his asylum case. Because one might think that as soon as the other EU state had cleared him, that he would be like at 0 and not minus. But it turned out that everyone thought that for some reason this was his fault. He was lying or something was wrong with him. So when he was telling them about his asylum claims, they were actually mistrusting him from the beginning. And for us, as his legal representation, we had also some really big problems. First of all, we couldn't get all the information or the documents we needed to challenge the claims made by the government. We could get documents from the Swedish government of Migration Board, but we couldn't get it from the other EU states. And that was also because we didn't really know how to get them. We didn't really know who to ask, how to make or asking for them. So we couldn't get them. So we didn't have any possibility to do our own matching of the fingerprints. And of course, that was first of all because we didn't have the documents to make the match. But second, if we had them, we had to find someone who could do this match for us. And that is not super easy. And also, that costs money. Asylum seekers do not have that kind of money to do that by themselves. And one more thing is that even if we had done it, the credibility of such a test would not be as high as the one that the state made. So even if we had one saying the opposite from the state would always choose the one they did. So actually, no matter what we wrote or what evidence we would have had, or what we had, because we had evidence, the state said that the fingerprint match was the truth and was not up for challenge. So we couldn't do anything about it. And then we had some troubles getting in contact with our client. Since we had a language barrier, we needed an interpreter, for example. And because of the Swedish regulation, we had problems talking to our client as much as we wanted, and that affected him and, of course, the case as well. The interesting thing is that he got no explanation nor an apology when the mistake was found out. Neither did we. Neither did he get any compensation of any kind for the mistake. And as you could see, it affected him heavily. And it was also difficult for us to know who was responsible for this mistake. If we were going to make claims to someone, who will we target? Is it the Swedish government? Is it the other EU state? Is it both? Is it someone else? Who is it? So it was really difficult for us to know exactly what had happened when we didn't even get an explanation. And we didn't get the papers or the documents we needed to find out. That was the first case. And then I wanted to talk a little bit about incorrect registration of name and or date of birth, because that happens a lot. Oh, it's more common than the other case with the fingerprints. Well, during 2015 and the beginning of 2016, as you all know, there was a lot of people fleeing through Europe. The situation was somewhat chaotic in many places. And upon arrival in Sweden, many of the asylum seekers turned out to have fingerprints in other countries. The comparison with the fingerprints was normally not a problem. The problem came when the registration in the other country did not match the information about name and date of birth. These problems were not, as you might think, only a problem during the year of 2015 and 2016, but it came to light in a more obvious way during this period of time. The majority of the asylum seekers claimed that they had no interpreter while stating their name and date of birth. This is to say in most countries. And this is our asylum seekers, not everyone, but the clients we had. They had no legal representation nor appointed caretaker if they were minors during the registration. And the majority could not use or understand Latin letters. Many said they were never asked about their exact date of birth, but sometimes they were asked to write it down and someone else helped them. Sometimes they said how old they were, but without giving an exact date. Most of the Afghans stated their age or year of birth according to the Persian Afghan calendar, but had no idea if the state converted it to Gregorian calendar in a correct way. Almost everyone said that they did not know what name or date of birth the other country really registered. No one were able to control or had been given any opportunity to see the information, much less to change it. And the consequences of this was that they were mistrusted, not only with their identity, but also the credibility of their given asylum claims. The possibility that the country made a mistake or did not care about a correct registration was not an option for the state. The first registration was the correct one. There was almost no possibility to change what was already in the system. If the asylum seeker had a passport, the registration could be changed, but any other identification documents, more or less, was not valid for changing this. Most of the Afghans, for example, had a tazkira, their identification document, and that was not something that the Swedish government, at least, accepted. And children seeking asylum was considered adults, because with the registration of adult in another EU country, they were considered adults no matter what. Even though the children really described how the registration was done and the lack of interpreter and the lack of help, the Swedish government didn't really accept it. So they were considered adults. Being considered adults and having fingerprints in another country means that you will be sent to that country. And of course, in that country, they will be treated as adults and will not get the help they needed. If the asylum seeker as well was granted asylum, but in the wrong name, it can be the spelling or for some reason wrong name or date of birth, you could have problems later on as well. For example, if you get a passport from your own country, your home country where you're a citizen, and that name doesn't match the name that you registered in Sweden, you can have problems when you enter or you leave or enter Sweden. Or if you want to apply for citizenship in Sweden, you have to give them some kind of identification document from your own country. And if that doesn't match the one in Sweden, you will not be able to be a citizen. So that's a problem as well. And one of the most important ones for our Afghan asylum seekers is the family applications. If the identity don't match the identity in the other country, the families will not be able to have any reunion in Sweden at all. They will be denied a permission to come in Sweden. And this is just some problems. I can tell you like 1,000 more. But we battle with this every day, I must say. And it's not only a few countries in Europe. It is every country in Europe that has this kind of problems, although it's a bigger problem in some countries. We see this as a result of deficient routines, but also the result of human mistakes. Mistakes that can give an effect on lives of the asylum seekers in an extremely negative way. Thank you.
Thank you very much. Thank you very much, Viktoria, for this very interesting presentation, and which illustrates how profound the implications of these cases are for the ownership of the data and the problems with access to justice, to seek remedies. You know, there are, which complaint mechanisms do we have, if any, for people to seek remedies? And you mentioned to whom to address these complaints is a question mark. Perhaps, hopefully, we will come back to that later as well. The next presentation is by Ove Langfeldt. He's working at the EDPS, and he's a legal officer in the Supervision and Enforcement Unit. Ove, you have the floor.
Thank you for having me. And, well, first of all, good afternoon. I'll be talking about this in keeping with the spirit of the panel, more from the practical side. What do we, as EDPS, as supervisor for EULISA and the central systems of these large-scale IT systems do? What do our colleagues in the member state and the member states' DPAs do? So just to have also, in keeping with what Viktoria did before, a bit of view from the ground, so less large-scale policy debate on the border regime, how it's supposed to look in 2030. Hope this, there we go. So just as a quick overview on, call it a generic system, some slight differences between them, but the broad things, you've got a central unit. In these systems we're talking about, SIS with Eurodac now, it's always EULISA who's running those, and Europol has access in some cases, and member state authorities use that. What we as the EDPS do for the EULISA side is the activities, supervising the activities of the central unit and the communication infrastructure around. Since the new, well, not that new anymore, Europol regulation, the current Europol regulation became applicable, we also supervise Europol. Before there used to be a special separate body for that. Now, that's what happens on our side. What happens on the side of the member states is that the competent authorities in the member states who are feeding the system, putting in the data, and we're accessing them, using them, they are supervised by the colleagues in the member state DPA, so the CNIL, the ICO, and so on. What do we do on our side? We do regular inspections. Each of these systems have in the Establishing Act an obligation for us to ensure that in a regular interval, 3 or 4 years usually, an audit according to international standard is carried out. We've got 3 of those systems in operational use. There are more coming. So the math adds up quite easily. We're basically at EULISA every year, and we'll be there even more in the future. What we look at in the inspections is basically on the parts that EULISA is supposed to do. So it's information security and the operational management of the systems. bit less on the content because, not on the content, because whether the content uploaded into the system, so whether a European arrest warrant entered into the SIS is correct and should be there, that is the responsibility of the member state authority that enters it. We get consultations from the EU LISA on how to deal with certain things. In the end, it's often the same question. What can EU LISA do and what is for member states to do? Where does the borderline lie? Our generic answer on that is what EU LISA's job is to keep the systems up and running and to do the further development as necessary. Ensuring data quality in the sense that the names in visa applications are correct, that they mix up in the passport numbers in there and so on. That's basically for the member states to do. Now, member states can ask for tools to make their job easier, but in the end it's still on them. So we wouldn't want, and that's also, if you look at how the systems have been set up, both in their own establishing acts and the EU LISA regulation, was that EU LISA is, say, a bit more than a service provider, but not the European central behemoth dealing with all these things. No, the legislator's choice was to have that responsibility on the member state level. Complaints, Viktoria mentioned complaints already. Now, there are, let's say, two aspects to that. Complaints against being registered in the system or not receiving access to data that is about you in a system. Those are to be lodged with the national DPAs. What would be for us was if EU LISA were up to do unlawful things with the data, or if there had been a large-scale breach in EU LISA. Those kinds of things would be more for us. Now, in practice, yes, we do get complaints, but they're in the end cases like the ones Viktoria talked about. So it's people asking, I didn't get my visa, what can I do? Or I've got these problems with the SIS. And there, in the end, we can't do much more than explain the legal framework to them and refer them back to the relevant authorities, either the member state competent authorities, so it's the visa authority if it's something about the VIS, or if they have already been in contact and were not happy with the reply to, let's say, an access request, the competent national DPA. So, on the member state side, what do they do? Again, they supervise the national use, including national copies where they exist, it's basically in the SIS. So they do inspections of the national interfaces to the central systems. They sometimes check in the consulates of the member states abroad how things work. They do inspection in the Ciarán bureaus, so the international cooperation units in their police forces, and again also deal with complaints, consultations, etc. That is, of course, as the DPA, so to say, the third line of defense. The first line of defense is that the authorities should do their job right, that it's the officer on the ground doing the correct thing. Then second line would be the internal control mechanisms. So I've seen that, for example, in some member states, the DPO of the national police does some random checks. So a police officer could receive a message. We've got doing a check here on date X, time Y. You looked up person Z in the SIS. Explain what was your lawful reason to do that, and not it's the new neighbor who looks a bit shady. Now, how do those two levels go together? In each of those systems, there is what's called a Supervision Coordination group. This is with Eurodac, where member state DPAs and EDPS are represented as members, as supervisors of those systems. I'm the member for the EDPS in most of those. We also provide the secretariat. It's my colleague sitting over there. Now, basically, what the secretariat does and what these groups also do is analyze common problems in the application of these systems. So could be member state, one member state DPA asking, we have a issue with what our police forces do with one of the systems. Do you have similar issues? How do you deal with that? How do we come to a common solution? So what we've done in these groups were also to develop template inspections plans, had a report on advanced deletion in Eurodac, basically how to get out your data before the end of the retention period in case you become an EU national before that. Now, that's basically what we do in those two groups to kind of bring the two levels together. These groups are, which may be more of a technical inside baseball point, they're in the end coordination groups. So for those of you who remember the Europol JSB, who know the Eurojust JSB, or even the old Schengen JSA, who used to be, or in the case of the Eurojust JSB, still are supervisory bodies in their own right, who do take decisions. These groups are in the end about coordination between supervisors. Now, where do we go from here? This whole field is, as Diana explained in her introduction, and also what came up in Lotta's presentation, quite in a dynamic development. We've got these three systems out. EES is adopted, ETIAS, ECRIS-TCN may come more. Sometimes they're a bit more complicated in the architecture. If you look at ETIAS, where you not only have EU-LISA on the central side, but also role for Frontex, slightly variable geometry. So this is indeed an interesting area, let's say, to watch. Now, quickly going back to the guiding questions for the panel, so right of information. Now, the legal framework basically says we have to inform people. That, in with Eurodac, this of course is a slightly different question. So on that side, it seems to be okay, but indeed it's a question of applying it on the ground, not just putting a printed notice in front of people, but explaining what is going to happen. Then the computer says no problem. The case with the fingerprint match, for example, Viktoria talked about. Again, this is currently still on the member states. They have to check, but then again, with the new proposals, EU-LISA's role may grow there. And finally, in my last 10 seconds, implications for other rights, or in general, the whole thing. These large-scale information systems are in the end tools to support policy goals, as is interoperability. Sometimes you get the impression that some of the proposals were written rather quickly with the sense of we have to do something, this is something. Just think it through, clearly define the problem that you're trying to solve, and then come up with a solution to that problem, and maybe not also a different problem. On this, thank you, and done.
Thank you very much indeed for your address. One wonders about this moment, the moment when the immigration authorities or the police authorities meet the person and everything happens, if that monitoring system can catch up. Because do we have an impartial, independent, regular monitoring at that moment when becomes so decisive, as the previous presentation clarified, the guarantees and the access to remedies. And you were saying that the member states keep, indeed, rightly so, main responsibility. What they do, however, falls within the scope of EU law, and as such, is captured by the EU Charter of Fundamental Rights, and they must comply with fundamental rights even there. Now, when you add EU agencies to the picture, then it becomes even more beautiful and flowery. We do have now EU-LISA mandate being renewed with an express mention of interoperability even before we knew what interoperability meant. And EU-LISA has a number of important tasks, and we look forward to hearing the presentation by Ciarán Carolan. He's Research and Development Officer at EU-LISA. You have the floor.
Thank you very much, Sergio. So today I want to very quickly give you a brief overview of what's happening in this space, a little bit compliments to what you've heard already in many cases. Look briefly at strategic view on why IT systems are developing, at least from my perspective, and why they're being applied in the ways that they are, and why they're being increasingly envisaged for new solutions, should we say, like you've heard already. And then secondly, move forward a little bit with looking at some of the fundamental rights, should we say, implications, or the way we're addressing fundamental rights in the systems, how we're improving the current systems in terms of fundamental rights, and to highlight to you as well for systems that we're developing at the EU-LISA side, and in general, I would believe in terms of legislative work, how data protection by design and privacy by design are really being applied in the systems development work. So let me begin, as I say, with the strategic view on importance of technology, importance of IT generally. So this picture you've seen already, or something very, very similar, at least in the opening presentation. You can see many systems existing, 3 existing right now, but many, many more systems to come. And you can also see the purposes, or let's say the category of person associated to these systems, and you can see that in most ways, at least, they're complementary and applying to different categories of travellers, and shown in the jigsaw type formation here, really interacting with each other, completing gaps that currently exist with the 3 systems is one of the themes that's being looked at with the introduction of entry-exit system ETIAS, for example, and also shown by the jigsaw, interoperability is intended to be shown, at least, and that's something that has been highlighted already. So why are these systems being introduced, or generally looking at technology and IT systems? What are they supposed to be doing? Well, I'm going to show quickly 5 objectives, and maybe not go through each of them because of time, but the objectives of these generally are to facilitate information exchange. So that's important in the world that we live in, and I'll speak about it in Europe. The way things operate nowadays with cross-border cooperation is, in the Justice and Home Affairs domain, critical. And I don't think it can be done efficiently and effectively without some form of IT. So fundamentally, it's information exchange. And you can say it's data exchange, and what's important is the data then is turned into information. So we're providing data, and used in the context in which it's used, you get information to guide your decision making. There's also the element of common standards and best practices. That's not just at the IT level, I mean, there's the element of the process. It's also touched on by the top there, the holistic view on processes and systems. By applying IT, and by applying systems, you, by implication, somehow imply that processes associated with these systems are more harmonized. So that's also something that technology can bring, and is one reason why some of the developments proposed are being introduced. For example, the European Search Portal, one goal is particularly to harmonize use and access to the systems to make sure that each member state is doing the same as every other member state in terms of queries and transactions. So looking at these objectives more at the EU side, as I say, in an area without internal borders, information exchange is critical. So the primary impetus, I suppose, for development of these systems is the establishment of Schengen. And the fact that Schengen exists means countries need to cooperate, and without IT systems, I don't believe it could be done in any way efficiently. It probably could not be done at all. Harmonized processes and procedures. So I'll touch on that a little bit later, but this enhances, to my mind at least, trust. One of the issues with re-establishment of internal borders in the last couple of years has been a breakdown of trust between member states, because, for example, they don't believe they're utilizing the systems or utilizing them correctly or getting the right information. So hence they decide, I must do it myself because I don't trust my neighbor. IT systems and the harmonization that IT systems can bring can establish the harmonized procedures, harmonized processes, and re-establish this trust between countries. And finally, reduce costs. I say it's probably impossible to do this without IT systems. That's surely the case, but certainly even if you tried it without IT systems, it would be infinitely more expensive if it's possible at all. So reduce costs through the efficiency gains that's undertaken. As we move more towards technologies, just the systems, things like smart borders, the introduction of automated border controls, self-service kiosks are all mentioned in light of entry-exit system. These are all being spoken about primarily, I would say primarily because of reduced costs, self-service, etc. So moving on to second part of the presentation, how does data protection and privacy apply in the context of these developments? And this slide here is really intended to say the same as what Ove just explained a moment ago, probably better than I can do it, but this, as Ove mentioned, is EU-LISA's domain of responsibility, administering the central systems and what's intended to be shown by the blue line, the connection network between the central system, or the communication network, I should say, and the terminals that are in place let's say the access point at least, at the member state level. In terms of EU LISA's sphere of influence, we can say it's slightly wider. And this goes to the idea that Ove also mentioned, that we can, to some extent, influence the structure of the interfaces, the checks that might be implemented at interfaces to make sure, for example, data quality is appropriately implemented. So we can provide tools for the member states to do their work more effectively, for example, provide higher quality data, but we cannot influence and never will influence unless something significantly changes activities regarding processes, etc., that Viktoria brought up. It's not something that our activities touch upon at all, so that's just the reality. Then in terms, I want to focus on two items that Lotta spoke about in her presentation, and areas for concern, and just briefly tell you what EU LISA and Europe in general is doing to improve matters in terms of fundamental rights around these. One is data quality, and in this area there's already a lot being done incrementally around the systems to improve the quality of data. Building, I would say, on a solid base. So the quality of data and the statistics that Lotta showed already show that generally, I think, quality is quite good, but that's not to say it cannot be improved, and that's what we're trying to do. We've already, for over 1 year, have in place an action plan that's been coordinated with the Council working parties to improve data quality. It's the member state responsibility to ensure the quality of the data input, of course, but we're helping them. How? Well, amongst what we're doing, technical checks at the interfaces. So as data is uploaded centrally, checking that it conforms to certain rules, and where appropriate, for example, with biometrics, providing kits to the member states so that they can also undertake harmonized appropriate checks on the biometric quality at their level before submitting them to the central infrastructure. Better feedback of statistics. Unless they know where the errors are, it's very hard to fix them. So by providing statistics and reports back, they can identify where problems are and hopefully take remedial actions. Training is something that's important, and we've been increasingly incorporating data quality related matters into the training that we do with member states. And something that we don't do, but we're trying to get the many collaborators on this action plan, for example, the agencies, Europol, Frontex, etc., to look at processes and see where processes can maybe be altered or changed to ensure that there's appropriate consideration given to inputting high quality data. Technologies are used, for example, automated document readers, etc., to make sure that the officers, border guard officers, police officers are not typing information in manually, but utilizing technologies to make sure it is taken from reliable sources. It's more efficient and it's more effective. That's what I mean by enhanced technologies. Some policy developments of relevance, I think Ove mentioned it already. Evolution of EU LISA's mandate, that's the new proposal. It references a role in data quality improvements specifically. There's also the idea in interoperability, and I don't believe it has been mentioned, this central repository for reporting and statistics that can improve this provision of quality-focused statistics back to member states to allow them to identify remedial actions. And also in terms of interoperability, what Lotta touched upon, the identity repository, the linking of identities, it offers better possibilities for detecting and correcting errors of identity. So with this information in place, there has to be also the appropriate processes to make sure that remedial actions are taken and errors in identity are corrected by the member states who are responsible for these corrections. The second area that I can speak about a little bit is access to data, also touched upon by Lotta. This is something where at the moment the access control at central level to the systems is very, very minimal. That should increase with the concept of the European search portal and the associated idea of access profiles in this search portal. So there will be profiles determining what, let's say, role the person has, whether they're a border guard, whether they're a police officer, an asylum officer, etc., and also the authority and where they're coming from, which is much more significant than the information we receive right now. The profiles, the nature of them still has to be defined, but at least this seems to be the idea. This will allow enhanced central control alongside the important national control of system access, improved auditability, because there's more relevant information available to check who accessed what at what time, and then, as Ove said, inquire about what the purposes of these checks were. And just to note, for interoperability generally, there is no change in user access rights. This is not giving authorities or individuals within those authorities any access to information that they don't have according to legislation currently, and is provided for in the individual system legislation. But interoperability is providing better ways to check and ensure that the access is undertaken in line with the legal base. I think it's my final slide, positive fundamental rights effects, or second last I should say, positive fundamental rights effects of data collection. I say potential because, of course it's potential, it depends on how it's done. One, in terms of collecting extra data, and this is something that we could discuss ad infinitum, but I think it's important to mention. When you, for example, add facial recognition to the systems, it allows for improved performance and increasing accuracy. And what's relevant to when you add facial image to systems, you add something that officers can visually prove, visually look at and confirm at their terminal this is the same person or not, which is not the case typically with fingerprints. So sometimes adding some extra data on can improve the performance, and the net effect can be positive, at least I would argue. Addressing challenges on missing persons, vulnerable persons, Lotta alluded to that, and enhanced trust, I explained that already. That's important because I would say establishment of borders and closing things is not a positive fundamental right aspect for anybody either. So the enhanced trust of systems is something that can, for example, allow the opening of borders and allow people to access asylum procedures. That's in some instances not currently possible because of the shutting of the borders in that way. Final slide, future work, something in the research and development area that I work on, that we're looking on. I think it's increasingly important in the context of artificial intelligence, etc. Risk assessment, it comes into context with ETIAS, with PNR, API, etc. Will we have algorithms deciding things that nobody understands and nobody can rebut? We've taken these questions on board, and it is a very, very valid question. And we're looking about examining how to use understandable, auditable algorithms that would potentially arise in these systems through machine learning, but would be understandable, and everybody could see how they're working and debate the merits of these algorithms in that way. So I'll leave it there. Thank you.
Thank you very much for your presentation, Ciarán. Indeed, this is a highly technical discussion, which of course hides a profoundly important political and legal repercussions for everyone. And you end one of the messages in your presentation was enhancing trust. And I was just wondering really whether interoperability will actually bring more or less trust. From the previous presentation, we clearly saw that for asylum seekers, we have evidence showing that this leads to mistrust, more mistrust on asylum seekers. But even at the authorities level, does it sharing more and more, this maximization of data, lead to more cooperation at EU level, more trust in EU cooperation, or more mistrust in sharing less when you don't know who has access to what, under which conditions, which checks and balances, and so on? This is just a question I had. I will give now the floor to Diana. He will moderate.
Thank you very much. Indeed, we have just 6 minutes left. I also will raise a small question or remark, and then I'll open the floor to all of you. Ciarán, you also mentioned on your slide that you're working on process redesign to focus on data quality. And I was just wondering if you look at the entry-exit system proposal, where a lot of the, actually all the data will be enrolled at the border by the border guards when they're so pressed for time and they need to actually process so many passengers. Do you think that this will as a process design that will really contribute to data quality?
Thanks for the question. So just to emphasize once again, I said it, but to repeat it, we don't work on processes, but we have included in our plan that we're coordinating with many collaborators. In terms of process design around entry-exit system, which you gave, that can entail, for example, the utilization of self-service mechanisms so that you don't encounter this issue with border guards being pressed for time, because essentially the border guard is taken out of the equation for the administrative type of processes like biometric enrollment. So that's one element of it, and where you do consult a border guard, he or she should have more time because there's less pressure on them. So that's something that's being looked at. The other elements, I think I touched on it again, but in the slides already, it's the utilization of technologies around these for the data collection. So it's making sure that, for example, full page document readers are used, full scanners, appropriate high quality technology with minimum standards to make sure, for example, that errors in reading the machine readable zone on a document are not made if you're using high quality equipment rather than older types of items. So really looking at the overall use of technologies within the process and making sure there's a logical flow to elements as well, so that you're passing the person through the process in an understandable way for quality purposes.
Thank you very much. Okay, we can argue on whether the self-service kiosks in themselves will lead to better data quality or not, but I don't want to take the opportunity of the panelists to raise questions. I saw Gloria eagerly raising her hand, so please go ahead with your question, but please be short and concise because we are running out of time. Thank you.
Thank you. So Gloria González-Fuster from the Free University of Brussels. It was really a beautiful panel, and I really like the gap between the first part and the second part. The first part is about what happens in practice and how data subject rights are just inexistent, and we know this, we learn this every time somebody wonders what happens in practice. We knew this from a Eurodac report many years ago. The rights of the data subjects are not respected in practice. There are legal frameworks, there are technologies, but nobody cares. And then the answer is, well, we are focusing on data quality, the algorithm, and blah, blah, blah. But I wonder who then cares, who is doing something? Do you know who will do something about the compliance in practice with data subject rights? Thank you.
So I see two more questions. So Gemma and Els. So can you please bring the microphone to? Yeah.
It's something that may sound a bit off topic, but I think it is and may become very relevant. Automation is hugely impacting not only all the things that you mentioned, but also the labor rights of border guards. And one of the things that we've found working on these issues was that there was some difficulties. I don't know how to put it. Some border guards did complain about the impact of automation in their work, and I haven't seen anything on the impact of automation on labor rights in this specific area. I haven't seen anything on many areas, but I think that we're finding that at border crossings, automation is having a huge impact in terms of rewriting the job description of border guards. So I was thinking whether anyone's working on these issues, because we're finding it really hard to find literature to base our analysis on. Thank you.
Thank you for the observation. I saw there was one last question from Els. So.
Thank you, Elskind from KU Leuven. Thank you for the discussion in the panel and the presentations. I have a twofold question. First, my question, the core of the presentation touches upon biometric data, and I would like to hear from the panel, from you, whether you have any observations with regard to how biometric data now have been tackled in the GDPR in general. It has been defined, and there is a prohibition in Article 9 for using biometric data as defined for uniquely identifying individuals. So first question is, do you have any observation on that definition? Second, you have been discussing indeed use of biometric data in the large-scale systems, and I think it's very important to keep here in mind that, as I said, biometric data is used to identify. In other words, it becomes, or it is a unique identifier, so it allows interoperability, very important for some public interest purposes, but it also allows to combine information to track and trace people. And the backdrop from these systems is that people can be tracked and traced, that the system, once the biometrics are stored in large scale, that it can be easily used for other purposes. We have seen that in Eurodac. It was first just for attribute responsibility to member states for the Asylum procedure. Now law enforcement has access, so you see very easy a function creep used for other purposes. So my question would there be, how can you design safeguards for that, that indeed once it is collected and stored in systems, it cannot later on be expanded and used for other purposes? And maybe we have to keep in mind as well, first it's them that are stored in the systems, and later it may be us being tracked and traced based on our biometric identifiers. Thank you.
Thank you for the question. Who wants to take a stand on? Yep, please, Lotta.
Thank you. I will just very quickly run through all the interesting questions. All of them would merit a long discussion, but I will just spontaneously react to I hope all of them in one go. Yes, what about complaints from an institutional level, which is very legally driven and institutionalized, with a complaint system to EDPS, to national data protection authorities, we do not always work. And we have seen that the topics on the practical level are just so real. I think in this context there is just one way to go, and to look very to differentiate between two ways to look at this. One is to increase the possibility for the person concerned in the case to lay more weight on the arguments of the person, the more trust in plausible explanations of the asylum seeker, for instance, when he or she is claiming, no, that is not how my name is written, for instance. And the other way is then to enhance capacities of the more institutional ways, NDP, the National Data Protection Authorities, for instance, by having, for instance, legal training for lawyers who really become specialized in this field. And EU could put money aside to support this, I think. Automation on labor rights, absolutely. This is something which would merit a lot of discussion, probably not only in the field of borders, but generally what the automation of decision making does when it comes to fundamental rights, and even rule of law values in the larger context. If you start to bring that discussion onto surveillance. Situations and storing of large amount of biometric data. The new data protection framework, it prohibits processing, but it also has a lot of exceptions for that processing. And it also ends, in the end, the way we have been looking at this issue, it's end up in a very careful balancing at what stage is more information in the interest of the person, storing, or more information in the interest of the person, and when it is too much. It's indeed a very, very tricky question. The issue with the unique identifier and the biometrics, indeed, it is the more information you gather about the person, which you will have by having it easily available through the interoperability systems and the added purposes that allows, meaning that more and more authorities can access that information. It becomes so absolutely crucial that there is no quality issues, no mistakes, no administrative mistakes. The discussion now has focused very much about the quality, but we have administrative mistakes, which we found out are very, very important as well in the context, which then leads to in the worst case scenario, wrong decision in that case. So what could be done is to look very careful in what are the safeguards, and also critically monitor what's going on. At what point does the access rule, let's say the legal developments have made the access rules almost irrelevant, if I put it really dramatically.
Thank you very much. Do the other panelists want to respond to the questions asked?
No, the compliance on the ground question. Indeed, this thing now, obviously we can't have a DPA behind every border guard or asylum officer. For example, in the example of Eurodac, in the Eurodac SCG, it's just one of the things that are just on our plate right now, that we'll look into that a bit more closely. There's also another thing, because as you can imagine, with all the new systems, plus other law enforcement developments, plus GDPR in general, the DPAs have a lot of work on their plate. Now, if you look into the legal basis for these different systems, there's always a nice sentence saying, and the member states shall ensure that the DPAs have sufficient funds to fulfill their task under these regulations. So we asked the members those questions. Did you have any additional funds for that? The answer was usually no. So we're also between, call it a rock and a hard place here. On the unique identifier question and the risk for mission creep or eroding safeguards with interoperability, that's indeed one of the core problems we still have with that. It's not that interoperability as such will automatically lead to that, but it may create a possibility. And that's just something where then both the legislator in defining how it's going to work exactly has to be very vigilant, as well as the supervisory authorities in their compliance function once the systems are actually operational on the ground, to really make the competent authorities stick to that and avoid mission creep as far as possible. That's what I would have to say on that. Thank you.
Thank you very much. If everybody wants to make a last statement, that is, I would give you the chance. If not, I think we can close the panel since we are already into the coffee break. So I wanted to thank all the panelists for all the nice observations, interventions you made, the audience for the nice questions, and again, the Fra and Lotte for organizing the panel. Thank you.
Thank you. Thanks, you all.